If you are over 60 or you have a parent, spouse, or loved one with money sitting in a bank account, do not ignore what I'm about to explain. Because after death, one bank account can become one of the most stressful problems a family faces. The money may be there, the family may need it, the funeral bill may be due, the mortgage may still need to be paid, the utilities may still be running. The surviving spouse may need money for groceries, medicine, rent, or basic bills. The children may be trying to handle final expenses while they are grieving, but the bank may say, "We cannot release this money yet." And that is when families panic, because they can see the money. They know the money exists. They may even know what the account owner wanted, but knowing is not always enough. The bank may need paperwork. Now, listen carefully. This does not mean the bank stole the money. This does not mean every account is frozen forever. This does not mean your family will lose everything. But it does mean one thing. If your bank account is not set up correctly before death, your family may face delays, court documents, probate problems, legal fees, family conflict, or weeks of confusion before they can access the money. And here is the part most seniors never hear. There may be a simple bank form that can help avoid that delay. It is often called a payable-on-death form. Some banks call it a POD form. Some call it a beneficiary designation. Some call it transfer-on-death instructions. Some may use different wording. But the idea is simple. You tell the bank who should receive the money in that account when you die. Not today, not while you are alive, only after death. And in many cases, this form may be free to file with your bank. That is why this warning matters, because many seniors have a will, many seniors have life insurance, many seniors have children they trust, many seniors have a spouse they believe will automatically handle everything. Many seniors think their family will just know what to do. But the bank does not follow family conversations. The bank does not follow memories. The bank does not follow what one child says you wanted. The bank follows paperwork, and if the right paperwork is missing, your family may have to wait. Stay with me, because in this video, I am going to show you why bank accounts can freeze after death, what the free form is, why a will may not be enough, the mistakes that can ruin the form, and the one question every senior should ask their bank before it is too late. And later in this video, I will show you the mistake that causes the biggest family fight after a parent dies. Before we go further, share this video with someone over 60. Not later, right now. Because one free bank form could save a family from weeks or months of confusion. And the time to file it is not after death. The time is while the account owner is still alive, able to sign, able to choose, and able to confirm everything in writing. Now, let's start with the first thing you need to understand. When people say a bank account freezes after death, they usually mean the bank will not allow normal access until the bank knows who has legal authority. That can happen when the account owner dies and there is no joint owner, no payable-on-death beneficiary, no trust arrangement, or no clear instruction on the account. The bank may need a death certificate. The bank may need court paperwork. The bank may need letters testamentary. The bank may need letters of administration. The bank may need proof of who has authority to act for the estate. And until the right person provides the right documents, the account may sit there. The money is not gone, but it may not be easy for the family to use. That is the painful part. Because bills do not stop just because someone dies. The funeral home may need payment. The rent or mortgage may still be due. Medical bills may arrive. Credit card bills may arrive. Property taxes may arrive. Insurance payments may still be due. A surviving spouse may need grocery money, and children may be trying to keep everything together while grieving. This is why seniors must not assume that having money in the bank is enough. The real question is not only, do I have money? The real question is, can the right person access it when I am gone? That question changes everything, because if the answer is no, your money may be sitting in the account while your family is stuck searching for documents, calling the bank, calling the courthouse, calling an attorney, and trying to understand a process they were never prepared for. That is where the free form comes in. The payable-on-death form is one of the simplest tools many bank customers can ask about. With this form, you name a beneficiary for a bank account. That beneficiary does not own the money while you are alive. They usually cannot withdraw it while you are alive. They usually cannot control your account while you are alive. They usually cannot use your debit card. They usually cannot move your money. They usually do not even need to know they are listed. But after you die, the bank may be able to transfer the funds to that beneficiary after receiving the required proof, such as a death certificate and identification. That is the power of the form. It can help the account pass outside the normal probate process. It can reduce delay, it can reduce confusion, it can reduce family fighting, and it can give the bank a clear instruction instead of forcing your family to guess. But here is the micro hook. This form only helps if it is filed before death. You cannot fix it after the account owner is gone. Your children cannot simply walk in later and say, "Dad wanted me to have it." Your spouse cannot always say, "I need access now." Your executor cannot always unlock the money instantly. Your will may not be enough to get immediate access. The bank may still require legal documents. That is why seniors need to act while they are alive, while they can sign, while they can choose, and while they can still update the account. Because after death, the family may have grief, they may have bills, they may have pressure, but they may not have authority. Now, let's talk about the biggest misunderstanding. Many seniors think a will controls every dollar they own. They say, "I already have a will." They say, "My children know what I want." They say, "My wife gets everything." They say, "My husband will handle it." They say, "My son handles my paperwork." They say, "My daughter is my executor." But here is the hidden problem. A will is important, but a will may still go through probate, and probate can take time. If a bank account has no joint owner and no beneficiary designation, it may become part of the estate. That means the bank may wait for legal authority before releasing the money. The family may have to go to court. They may have to wait for paperwork. They may have to prove who is allowed to act. They may have to deal with creditors. They may have to follow state rules. And during that time, the money can feel frozen. This is why the bank beneficiary form matters. A payable-on-death designation can tell the bank who gets that account directly after death. The account paperwork may control that transfer, not a conversation, not a memory, not what one child says, not what the family thinks is fair. Paperwork. That is why you must check it, because if your will says one thing and your bank beneficiary form says another, your family may be shocked. If your will says your children should split everything equally, but your bank account names only one child as beneficiary, the bank may follow the account form. If your will leaves money to your current spouse, but an old bank form still names a former spouse, a deceased spouse, or someone you no longer want listed, that can create serious confusion. If your will is updated but the bank account beneficiary is not updated, your family may face conflict. The mistake is not having a will. The mistake is assuming your will automatically fixes every bank account. And that is where many seniors get caught. They think the will is the master document, but some accounts follow beneficiary paperwork. That paperwork must match your real wishes. Now, here is the next warning. This free form is especially important for certain seniors. If you live alone, check it. If your spouse has passed away, check it. If your bank account is only in your name, check it. If you have adult children, check it. If you have a blended family, check it. If you remarried, check it. If you have stepchildren, check it. If you have one child helping you, but more than one child in the family, check it. If you move states, check it. If you change banks, check it. If you opened the account years ago, check it. If you do not remember who is listed, check it. Because old accounts create old mistakes. Maybe you opened the account 20 years ago. Maybe you listed your spouse. Maybe your spouse died. Maybe you never changed it. Maybe you listed one child when they were helping you. Maybe you now want all children included. Maybe you listed someone who moved away. Maybe the beneficiary's name changed after marriage. Maybe the bank merged. Maybe your paperwork was never completed. Maybe the form was filled out but never processed. Maybe you opened a new account and forgot to add the beneficiary. Maybe you assumed the beneficiary from one account automatically applies to all accounts. These things happen, and families often discover them at the worst possible time, after death, when nobody can ask the account owner what they meant. That is why the check must happen now. Not someday, not after the next holiday, not when someone gets sick, not when the family is already under pressure. Now. Call your bank, visit a branch. Ask clearly, do I have a payable-on-death beneficiary listed on this account? Who is listed? Are the names and percentages correct? Do I have a contingent beneficiary? What happens if my beneficiary dies before me? Does this apply to all my accounts or only this one? Can I update this form today? Can I receive written confirmation? That last question matters. Can I receive written confirmation? Because a form that nobody can prove may not protect your family, and a form you think you filed years ago may not be enough if the bank does not have it properly recorded. Now let's talk about the mistakes that can ruin the form. Mistake number 1, leaving the beneficiary blank. This sounds obvious, but many seniors assume the bank account automatically goes to family. It may not. If there is no joint owner, no beneficiary, no trust, and no other arrangement, the account may go through the estate process. That can mean court paperwork, that can mean delay, that can mean family stress, and that can mean money sitting untouched while bills continue. Mistake number 2, listing only one person when you intended to divide the money. This is one of the most dangerous mistakes. Some seniors list the child who helps them with errands. They think that child will share the money with the others. But after death, that child may not be legally required to share if the account form names only them. That creates anger. One child says, "Mom wanted me to split it." Another says, "Then why is your name the only one on the account?" The bank follows the form. The family fights. Do not rely on promises. Do not rely on "they will do the right thing." Do not rely on a conversation from years ago. Put the correct beneficiaries and percentages on the form. Mistake number 3, not naming a backup beneficiary. What if the person you name dies before you? What if they cannot be found? What if they refuse the money? What if there is a legal issue? What if they are no longer part of your life? If there is no backup beneficiary, the account may still face delays. Ask the bank whether you can name contingent beneficiaries. Mistake number 4, using nicknames or incomplete information. Do not write Bobby if the legal name is Robert James Miller. Do not use an old married name if the person has legally changed names. Do not misspell names. Do not leave out dates of birth if the bank asks for them. Do not guess social security numbers or addresses. Small errors can create delays. And after death, small errors become big problems because the person who made the form is no longer there to explain it. Mistake number 5, forgetting to update after life changes. Death, divorce, marriage, remarriage, new grandchildren, family conflict, a child with creditor problems, a beneficiary with special needs, a move to another state, a new bank account, a bank merger, a new will, a spouse passing away. All of these can change what you should do. A beneficiary form is not something you file once and forget forever. Review it. Mistake number 6, thinking the form covers every asset. A bank POD form may cover that specific bank account. It may not cover your house. It may not cover your car. It may not cover retirement accounts. It may not cover life insurance. It may not cover brokerage accounts unless they have their own transfer-on-death setup. It may not cover accounts at another bank. Each asset may need its own plan. That is why seniors should not confuse one form with a complete estate plan. It is useful, but it is not everything. Now, here is the micro hook I promised earlier. This is the mistake that causes the biggest family fight. Adding a child as a joint owner when you only meant to make them a helper. Many seniors do this because it feels easier. They add a son or daughter to the account so that child can pay bills, write checks, or help with online banking. But a joint owner may have rights to the money while you are alive. They may be able to withdraw funds. They may be able to transfer money. They may be able to close the account. They may be able to use a debit card. They may be able to see the account history. And after death, the account may pass to them, depending on the account terms and state law. That may not be what you intended. You may have meant, "My daughter is helping me." But the paperwork may say, "My daughter is an owner." That difference can change everything. So before adding someone to your account, ask the bank, is this person becoming an owner or only an authorized signer? Can they withdraw money without me? Can they close the account? What happens when I die? Does this account pass to them automatically? Could a payable-on-death beneficiary be better? Could a power of attorney be better? Could a separate bill-paying account be safer? Do not sign just because it feels convenient. Convenience today can create conflict tomorrow. This is especially important if you have more than one child. One child may live nearby and help every week. Another may live far away. A third may not know what is happening. If the nearby child is added as joint owner, the others may later believe that child received more than intended. This can destroy families, not because the parent wanted conflict, but because the paperwork was unclear, and once the parent is gone, every unclear decision becomes harder to explain. Now, let's talk about what your family may need after death. If there is a payable-on-death beneficiary listed, the bank may ask for a certified death certificate. The bank may ask for the beneficiary's identification. The bank may ask the beneficiary to complete a claim form. The bank may review the account. The bank may wait for pending transactions to clear. The bank may need time to process the request. This may not be instant, but it can be much simpler than probate. If there is no beneficiary, the bank may require court documents. That may mean the family needs to open probate or a small estate process, depending on the state and the amount of money. That can take longer. It can cost money. It can require legal help. And it can create stress when the family is already grieving. This is why the POD form is so powerful. It gives the bank a direct instruction. But remember, rules vary by state. Bank procedures vary. Account types vary. Some accounts may not allow the same setup. Some accounts may require all owners to sign. Some banks may use different language. So, do not guess. Ask your bank directly, and ask while you are alive. Because after death, your family may be able to provide documents, but they cannot create your missing instructions. Now, let's talk about scams and pressure. When someone dies, scammers move fast. They watch obituaries. They call family members. They pretend to be creditors. They pretend to be banks. They pretend to be probate services. They pretend there is an urgent fee. They may say, "We can unlock the account." They may say, "You must pay now." They may say, "There is a government form you must buy." They may say, "Your family will lose the money unless you act immediately." Be careful. A real bank beneficiary form should come from your bank. Do not download a random form from a stranger. Do not pay someone online who promises to unlock a deceased person's account. Do not give social security numbers to unknown callers. Do not send copies of death certificates to random emails. Do not trust anyone who pressures you to act secretly. And do not let a family member pressure you into naming them beneficiary without thinking. This form is powerful. That means it must be handled carefully. You should choose beneficiaries calmly. You should understand the consequences. You should update the form when life changes. You should store confirmation safely. You should tell the right trusted person where the documents are. And you should never sign because someone is rushing you. Now, here is the final checklist. If you are over 60, check these 7 things today. Number 1. Ask your bank if your account has a payable-on-death beneficiary. Do not assume. Ask. Number 2. Confirm the exact names listed. Make sure legal names are correct. Number 3. Check the percentages. If you want 3 children to split equally, make sure the form says that. Number 4. Name backup beneficiaries if your bank allows it. Do not leave the account exposed if the first beneficiary dies. Number 5. Review after major life events. Death, divorce, marriage, remarriage, moving, family conflict, spouse death, or opening a new account. Number 6. Do not confuse a joint owner with a beneficiary. A joint owner may have access while you are alive. A POD beneficiary usually receives money after death. Number 7. Get written confirmation. Do not rely on memory. Do not rely on verbal promises. Do not rely on, "I think we did that years ago." Before you leave, remember these 5 words: freeze, form, family, proof, update. Freeze means the account may be delayed after death if the paperwork is missing. Form means the payable-on-death form may help your family avoid probate delay. Family means your loved ones need clarity, not confusion. Proof means you should keep written confirmation. Update means the form must match your life today, not your life 20 years ago. So, when the title says your bank account could freeze after death unless you file this free form, this is what it means. The money may be there, but your family may not be able to touch it quickly. Your will may not unlock it immediately. Your children may not agree. Your spouse may face delays. Your funeral bills may arrive before the bank releases the money. And a simple missing form could create weeks or months of stress. So, check it now. Call your bank now. Ask about the payable-on-death form now. Review your beneficiaries now. Update old accounts now. Tell your family where the paperwork is now. Because after death, your family cannot fix what you never filed. and one free form today could protect the people you love tomorrow.